story I was reading yesterday, I wanted to get your view on. This is a violent stalker, right? He broke into his ex-partner's house in the middle of the night and attacked her. All right? He chased the woman upstairs into her property in Clifton, in Nottingham. This was September last year. And I'm sorry about this description, but he dragged her to the floor and he stamped on her chest. He kicked her in the ribs and he punched her repeatedly in the face before leaving. She was taken to hospital, treated for bruising and swelling, and of course, terrible shock. It was the second time in the space of 3 days that he had attacked her. What was his prison sentence? Guilty. What was his prison sentence? He was jailed for less than 2 years for that. See, stuff like that just shatters your belief in the justice system, doesn't it? Joseph Kotrie-Monson is a criminal defence lawyer. Hello, Joseph.
Good morning, Andrew.
Very good morning. It's been too long. I hope you're very well.
Right.
Good. Oh, I'm glad you're so enthusiastic about being on. Now, Joe, what's going on here? A situation like this, less than 2 years. I mean,
yeah,
it seems wrong to me.
You summarised it in all its florid detail, haven't you, Andrew? Horrific sounding and sustained attack, compounded by the fact that it seemed to be the second in just a few days. Was it a lenient sentence? Quite possibly, but just as maybe not. Sorry for the lawyer's answer, Andrew, but the challenge is that there is a degree of underreporting in terms of the way in which the sentence took place. I, like you, have read those articles. They all seem to come from a single syndicated source, a local Nottinghamshire journalist, in terms of the actual facts and words used. So what we can't tell is if there was mitigation. And of course, there's a guilty plea, but beyond that, why was this not something that might have got, let's say, 3 or 4 years or closer to the maximum for ABH? Because it does seem aggravated, doesn't it? ABH, assault occasioning actual bodily harm. It means an assault which is of a kind of very low to medium level of physical harm. So not GBH, we know that phrase, don't we? It means really serious harm. We have to start with the law, and I think there may have been an argument that he was guilty on the basis of the facts that you've just summarised of burglary, which could have resulted in a stiffer sentence. Prosecution have been known, sadly for financial reasons, especially in domestic cases, for undercharging cases to get them through court quicker and encourage pleas, not a habit, not a habit that most of the general public would approve of. But since their cuts of 20-odd% over the last 8 or 9 years, it's been a fairly common phenomenon, Andrew. Yeah. We have to, however, in his case, start with the law that he was charged with and pleaded guilty for, and it's ABH. Actually, for ABH, people generally don't go to prison, in fact.
So for actual bodily harm, people are not expecting a custodial sentence anymore?
This is the type of one where I'd expect somebody to go to prison, but once somebody pleads guilty, the chances of that are reduced. And of course, think of this as a 3-year sentence or a 2 3/4 year sentence, reduced to 1 year 9 months because of the guilty plea. But we don't have anything about the mitigation. Mental health issues in these types of cases go hand in hand. That could have provided substantial mitigation. But I'm speculating. A judge was sorry, go on.
No, I'm listening to everything that you're saying, and I have been in a court of law, not like you, but I was on a jury, and when an argument is presented to you in mitigation, suddenly you can find your emotions swinging from one side to the other. If you've got an advocate who really knows what they're doing, if I had Joseph Kotrie-Monson, I would expect him to be arguing my case and to sowing some doubt, some confusion, be it in the mind of a jury or anything else. But there's a judge sitting with a really acting on behalf of all of us and this poor woman, and I'm not a highly trained lawyer, as you can tell, but I just look at some things and I go, that doesn't seem to make any sense. That's all. It's a simplistic way of looking at it. I know it is.
There's all kinds of things there that I'd like to comment upon, not least the possibility, however dim it may seem, yet exciting, that you might one day be my client, Andrew. But yes, I think that there's a possibility that judges are emotionally swayed. I suspect this was actually an analytical exercise, and it may well be, and again I'm speculating because we've only got half the story. It's very difficult to see if there was a reason why this sentence was the one it was. But let me talk to you about the prosecution's mechanism or recourse if they don't agree with the sentence, and that's that they can ask for the Attorney General, Suella Braverman, to refer the case to the Court of Appeal under the unduly lenient sentences scheme. These types of cases that are reported, often just as a result of the press involvement, or the press interest, just as a result of the types of conversations we're having that make people think, well, the public might want to know more about this. They often make their way to the Court of Appeal. I hope I'm not jinxing it by talking about it, but either way, and I think
that is
the reality is that mechanism does exist.
Okay.
It may be the prosecutors on balance decide it probably was the right sentence. I don't know.
Joseph, I hope I never need your services in a professional sense, but it's nice to actually speak to you again. Joseph Kotrie-Monson, criminal defence lawyer.